Assalamualaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask me any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters, personal injury law matters. So whatever your legal questions are, please do feel free to get in touch. Two ways to get in touch with us. You can call us on the landline number which appears at the bottom of the screen and you can speak to me live on air. Alternatively, another very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So the landline number to speak to me live on air and the mobile number to send us messages in, WhatsApp messages, etc. So those messages will come through to me here live in the studio and I'll be able to address your questions as they come in. A couple of minor points before we get going. On a live show, it's not always possible to take very detailed information from callers who call in. Sometimes it transpires that your matter is complex and I need very detailed information from you, or I might need to look at your documents before I advise you properly. Now, if that's the case, if I need to speak to you in depth or I need to look at your documents, then I will ask you to leave your number with the control room. I will try and give you a ring off air and then we can have this more thorough discussion off air. And again, this is a service that we provide completely free of charge as part of the free legal advice show. As always, we get a lot of questions in on immigration law, which is fantastic. Even before we've come on today, we've had a number of questions coming in, which I will start addressing as we go on with the show. But as I said before, I can deal with other legal matters as well, other popular matters such as family law queries, criminal law matters. Whatever your questions are, please do feel free to get in touch on those two methods that I have outlined previously. Now, let's look at one of the first questions that have come in today. It is an immigration law question, always very popular, and it's to do with work permits, or what's now referred to as a skilled worker visa. In practice, a lot of lawyers are getting queries in relation to skilled worker visas, how somebody can come to the United Kingdom to work, or if they're already here in the UK, maybe as a student, maybe on some other visa, how they can stay in the United Kingdom in order to work. So a lot of questions are coming in practice in relation to that. And one of the first questions that we've had in today relates to work permits and the healthcare visa. And the brother who's texted in says as follows: Assalamu alaikum. Please can you explain how this new healthcare visas work? I understand that the government has opened up visas for healthcare workers in the United Kingdom. Would you be able to explain the process relating to that? Interesting question. And as I said, in practice, you get a lot of questions on work permits, or the skilled worker visa, as it's now known. And in particular, there's been a lot more interest in the healthcare visa as well. Now, by way of background, work permits, Tier 2 visas, or the skilled worker visa, all these visas are similar in that they relate to somebody coming to the United Kingdom to work for a sponsor who is registered with the Home Office. And these visas have existed for years and years, decades. Previously, they were called, maybe going back 10, 15 years, maybe longer, they were called work permits. Recently, the name was changed to Tier 2 general visas. And the most recent change that came in last year was that they were relabeled as skilled worker visas. But essentially, they're all similar types of visas. And over the years, the requirements which need to be fulfilled have changed. Certainly, I've noticed that in terms of the latest skilled worker visa, there has been, this is one of the few areas of immigration law where there has been some more flexibility. It's been made easier to satisfy the requirements to sponsor somebody to the UK on a skilled worker visa, which is a big change from before. Essentially, a health worker visa is another type of skilled worker visa. Now, previously, health workers couldn't come to the United Kingdom in order to work for an employer. So you couldn't get a skilled worker visa based on doing healthcare work, because general healthcare work was deemed to be not sufficiently skilled. So that was the problem. Certainly, if you were coming as a nurse or if you were coming as a supervisor, that was sufficiently skilled for you to be able to get a skilled worker visa to come to the United Kingdom. The problem with a more basic level of healthcare work, very much at the more junior level, the problem was at the more junior level, it was deemed by the Home Office that the skill level of a more junior healthcare worker post wasn't at the appropriate level where you could sponsor somebody. So up until recently, it's not been possible to sponsor healthcare workers. In the last couple of months, there has been a change in the law where it has become easier to come and work in the United Kingdom as a healthcare worker. So that's been the biggest change here in the United Kingdom in terms of skilled worker visas. It is now possible to come to work as a healthcare assistant. Now, there are obviously certain requirements that need to be fulfilled when you do that. One of the main requirements is that the organization in the United Kingdom has to be registered with the Home Office. So it's not sufficient that you're a limited company or that you're registered with the tax office or that you're operating payroll. That's not the requirement that needs to be fulfilled by the UK business. The UK business has to be registered specifically with the Home Office in order to sponsor migrant workers here in the United Kingdom. So that's a specific registration process that the business has to go through. Once the business is registered with the Home Office to sponsor migrant workers, it's then possible to sponsor healthcare workers, for example, to work for them in the United Kingdom. There is a slight problem with the registration process in the sense that normally it used to take the Home Office about 2 months for a decision on a sponsor license application. Currently, it's taking longer. A lot of the immigration officers who are dealing with sponsored worker visas, who are dealing with the sponsor license, a lot of them have been redeployed to the team dealing with Ukrainian visas. So there's a shortage of staff in that particular team at the moment. So it is taking slightly longer for decisions on a sponsor license application. So instead of 2 months, it may take about 3 months for a decision on a sponsor license. But certainly, once you obtain your sponsor license here in the United Kingdom, it is then possible to employ somebody on a healthcare worker visa, or if your license is for another commercial organization, you may be an accountancy practice, you may be a pharmacist, a dental practice, then you're able to take people on to work for your practice as well. So the first requirement is that the organization has to be registered with the Home Office. They need to obtain a license. Once you've done that, it is relatively easy then to employ somebody to work for you. The main requirement that they need to fulfill is that they would need to pass an English test. So they would need to have an English qualification. Normally it's an IELTS qualification at level 4, band 4 in speaking, listening, reading and writing. So on the one hand, you as an organization would have to be registered with the Home Office. In terms of the employee would need to pass an English test. The English test is at a sort of a medium level English language requirement. So it's not the most basic of tests that need to be passed, and neither is it at the very highest level. It's somewhere in between. It's the kind of test where all four components are tested: your speaking ability, your ability to read and write English. So all your four components, speaking, listening, reading, writing, are tested. But it's at level 4, which is very much in the middle of the various bands that you have for English tests. Once the person who you're proposing to take on passes that test, it is a relatively easy process in terms of sponsoring a migrant worker. You'd request permission from the Home Office to employ the particular person. Once that permission has been granted by way of a certificate of sponsorship, that would be assigned to the employee, and the employee would apply for a visa. If they're abroad, they would apply for a visa from abroad. If they're already here on a student visa, some other visa, they would be able to transfer from their current visa into the skilled worker route as well. So, in essence, this scheme has been around for a long time. It's just that over the years, it's been transformed to meet the needs of the country, to meet the needs of the economy, and to meet the demands of businesses in the UK. So that's what's happened. Now, at the moment, we have a scheme which, in terms of the license, in terms of the visas, is probably at the most flexible that it's ever been. So it is absolutely possible to employ migrant workers now from abroad, and particularly in terms of healthcare workers, there is a route there if you're struggling to recruit people within the UK to employ somebody from abroad under that visa category. Hope that answers that particular question. We're taking a short break. I will be back in the next couple of minutes. See you then. Stop. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen. And as always, popular way of getting in touch is to send us a message on the mobile number which is also there at the bottom of the screen. Let's look at some of the questions that have been coming in. The next question that's come in relates to immigration matter, particularly relates to the BRP card that the Home Office issues to those who are in the United Kingdom from abroad. So the question is, our viewer says, I need help with this, please. My nationality is Eritrean, but I was born in Ethiopia. I have an Ethiopian nationality passport. I have been living in the UK with limited leave to remain with a biometric ID card. The biometric ID card refers to my Eritrean nationality and not my Ethiopian nationality. How can I change the nationality details from the Home Office? Now, the only way that this can be done is to apply for, normally what you should do is, once you get your BRP card, so you've applied for a visa, whether it's a spouse visa, refugee visa, whatever it is, when you receive your biometric residence permit, you should really look at the details on the permit straight away. Now, if there are any errors on the permit, then you would have to get in touch with the Home Office. Normally, you go on to an online form. Now, if you look at the letter that comes with your biometric residence permit, it will tell you which online form you need to go on to. So once you complete the online form, whilst you're completing it, you can tell the Home Office what the error is. And the Home Office will then let you know what you need to do, whether they're going to issue another card or not. So that's what normally happens when you get your biometric residence permit, you need to really look at it. And I think they give you 10 working days or so to look at it and get back to them if there's an error. Now, the problem is we don't know when this card was issued to you. I'm assuming you've had it a long time. But what you could still do is you can still get in touch with the Home Office and complete that online form and tell them that, look, this is the situation. Your nationality, your main nationality as you see it, is not what is stated on the BRP. You want the other nationality stated on the BRP. So you can explain to that on the online form. Now, I suspect they might come back to you and say, look, you've had it a long time. You've not raised this as an issue with us. Now, if that's the case, the only other way that you can deal with this is to make another application, a proper paid application, not for the visa that you already have, but for a replacement card to be issued to you with updated details. So if you think about it, where somebody's been issued with a card, maybe they've changed their name because they've got married, etc. There is a process for applying for a replacement card. So in the same way, it's a similar kind of process where you've seen an error on your card and you haven't dealt with it in time. You now want it dealt with. So you use the same process to update or request an updated card from the Home Office. You need to explain, why it is that you're unhappy with the details on the current biometric residence permit. Now, I haven't come across this particular issue before where somebody has dual nationality and there's a particular nationality that's been mentioned on the card and the applicant actually wants the other nationality on the card. I've not come across that situation before. But if you want details changed, and that does happen in practice quite regularly, then you would have to apply for the card to be replaced and replaced with your updated details. So that's what I would do. So it's a two-step process. One is complete, don't make a paid application straight away. Complete that online form that you can complete in order to report an error. So that particular form is reporting an error on the card. So first of all, deal with it that way and see whether that works or not. The reason I say deal with that process first is that there is no fee to pay for that. It's a simple form which is completed where you're reporting an error, and that may work. It does work, certainly when there are actual errors on the card. If it happens that the Home Office turn around and say, you know what, it's too late. If you want your details changed, you can't use this reporting an error process. You've got to apply for a replacement card, then so be it. You can apply for the replacement card. Now, in terms of fees, it's not too expensive. You're probably looking at something in the region of a few £100. Off the top of my head, it's something in the region of about £300 to apply for a replacement card. But that does require an online form to be completed. It requires the biometrics to be enrolled again. And it's a proper process that you need to go through. How long does it take to get it back? Generally speaking, replacement cards should be coming back within about 2 months or so, because it's not a full paid application where you're applying for leave to remain in the United Kingdom or you're changing visa categories. It's nothing that complex. It's simply a case of somebody who has existing leave in the United Kingdom asking for their details to be changed. So it's a much more simpler process. So it shouldn't take too long. Generally speaking, decisions come back within about 2 months or so. But there's no guarantee with the Home Office the way things are at the moment. So I hope that answers that particular question. Now, as always, if you want to speak to us live on it, you can ring on the landline number which appears at the bottom of the screen. And as always, please do continue to send your questions in on the mobile number which is also there at the bottom of the screen. We have another question that's come in relation to BRP again. And this is slightly different. This is a question relating to what happens when your BRP is about to expire. Salams, I was granted indefinite leave to remain approximately 5 years ago. My BRP expires in December 2024. What do I need to do? Common question, because a lot of people who were granted indefinite leave to remain would have been granted a card which has an expiry date of December 2024. All cards issued by the Home Office have this particular expiry date, December 2024. So this person has indefinite leave to remain already. So where the card states that the expiry date of the card is December 2024, your status of having indefinite leave to remain doesn't expire, obviously, in December 2024. What actually does happen is that it's just the card that needs to be updated. So the visa doesn't finish, it's just the card that needs to be updated. Now, the example that I normally give in practice is that compare it to having a driving license. You've passed your test, you've got your driving license. So driving licenses are normally valid for about 10 years. So when you get to the expiry date of your driving license, you don't need to do the whole test and everything again. Obviously, you're a qualified driver. You simply need to update your driving license. So that's basically the same situation in terms of somebody whose visa, somebody who has indefinite leave to remain in the United Kingdom, and but they have an expiry date of December 2024. Most cards have that kind of expiry date because by that date, the Home Office wants people to have a different kind of updated BRP card. So that's the aim that they have. So it's simply a case of applying for a replacement card. Again, it's relatively straightforward and it is quite cheap. I say that, but it does still cost something in the region of about £100 to £150 to replace an existing card. So that's where we are in terms of applying for a replacement card. Now, somebody who has indefinite leave to remain, they obviously have the option, if they meet all the requirements, to apply for nationality. Now, in my experience, the vast majority of people who have indefinite leave to remain will apply for nationality anyway. So the problem with their visa card expiring in December 2024 shouldn't normally arise for the vast majority of applicants. I would say 90% of people who have indefinite leave to remain will proceed to applying for nationality. And obviously, once they get nationality, it's then irrelevant that the card has expired because you don't need that card anymore. Indeed, the instructions are to cut up the card and return it to the Home Office because your status is then not of somebody who has indefinite leave to remain, but you, once you've got nationality, you are obviously a British national and you would have the passport, a British passport, which will confirm your citizenship status. So there's no need for that card anymore. So hope that answers the question on replacement BRPs. I think as we get closer to December 2024, we're going to have a lot more questions on this. The reason really for that is that the Home Office, when they used to issue BRPs, they've all been given an expiry date of December 2024. So there's going to be a lot of people applying for replacement cards as we get closer to December 2024. But there's nothing there to worry about. It's a relatively straightforward process. You make a simple online application and pay a fee, and within normally within about 6 weeks or so, you should get your updated card with the new logo and with more security features in there. So that's where we are. Probably a lot of questions on this will start coming up as we get closer to December 2024. Hope that answers that question. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, a popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. On this show, I'm able to cover a vast diverse range of matters, a vast diverse range of legal matters. Immigration law, family law, benefit law matters, etc. So please do send us your messages in or give us a ring on that landline number which is there at the bottom of the screen. Let's look at the next question that's come in, which relates to benefits, and in particular it relates to universal credits. Now let me read the question out, then let's look at what the legal position is. If a homeowner is on benefits such as universal credit, can they rent their properties to someone who is also on benefits and share the property with them whilst they pay rent? Will it have an effect on the owner's benefits? So can the property be rented out to a tenant? Both use the same address. Will it affect the owner's benefits that they receive? So I'm assuming they talking about universal credits. So universal credit is being received at the moment. If the owner who's in receipt of universal credit lets their property out to somebody else, and that person's paying rent, that person's on benefits as well, that person's paying rent, will, first of all, the owner's benefits be affected? I think then the second question is, will the tenant's benefits be affected? Now, if you look at universal credit, then the way universal credit works, it's a means-tested benefit. So the DWP, who administer the benefit, they look at your income and your savings. It's means-tested. So they look at your income and your savings when they assess how much in terms of benefits you are entitled to. So let's look at the fact that they assess your they assess your circumstances, and according to their formula, looking at your family circumstances, you're entitled to £700 a month. Now, if you have other income coming in, it can potentially affect your benefits. So it could be that once you declare that, look, you know what, I get £200 from a tenant, they will look at that as an income. And instead of you getting, in my example, £700 a month, they could say, now you've got an income coming in, so your universal credits will now be reduced. So it may be reduced by the amount of money you've got coming in. So in our example, where somebody previously was receiving £700 and now they've got a rental income of £200, potentially your the amount you get in universal credits could go down by £200, reducing it to £500. Now, that's how it generally works. There are some types of income which the Benefits Office will ignore. So, for example, if you take up part-time employment, then there is certain amount of money that you can earn without your benefits being affected. So, if you're on £700 a month in terms of benefits, and you're working and you're earning £200 a month from your job, then that may not have an impact on your benefits. It may not result in a reduction because there is a work allowance, a certain amount of work you can do, certain amount of money that you can earn. The amount you can earn from employment varies depending on whether your universal credit has a housing element or not. But generally speaking, in terms of work, if you are working then there will be a certain amount of money that you can earn without your benefits being affected. Once it goes above a certain threshold, then your benefits would go down. And there's a formula for working that out. Here, the question isn't about employment income. Here, the question is about rental income that you would be receiving. My understanding is that there is no allowance. There isn't any amount of money that you can earn without your benefits being impacted in that situation. My understanding is that if you get a rent in, that will have an immediate impact on the amount of benefits that you can get. So potentially, yes, there will be an impact on the benefits that you receive as the owner, because that's income. These benefits are means tested. If you need further information in relation to that, I would advise you to speak to the Citizens Advice Bureau. But my understanding is that the amount of benefits you get will be affected by any rental income that you receive. So you need to be careful about that. Now, the second part of your question is that would the tenant be affected at all? Well, the tenant might find that their benefits might go up, because if the tenant is now paying rent, which maybe they weren't paying rent before, then rent is something that is taken into account by DWP when working out how much what your entitlement is to universal credits. So, for example, if the tenant previously received benefits of £400 a month, and at that stage they weren't renting a property, so there was no rent that they had to pay. Now they are renting a property. There is, let's say, £200-300 a month rent to pay. They may be sharing a house, that's why it's less. Once they inform the benefits office of that, they may be requested to submit a tenancy agreement. But once that is done, what should happen is their benefits should go up to reflect the fact that this person has additional expenses, housing expenses. So on the one hand, for the owner of the property, if they've got rental income coming in, the likelihood is their benefit entitlement will go down. Whereas for the tenant, if they're having now to pay rent and they weren't paying rent before, that will result in them getting more in terms of benefits, so that they're able to not only pay for their own living costs, they are able to cover the cost of accommodation, and more specifically, the rental costs as well. So for the owner, a detrimental impact on the benefits would go down. For the tenant, the benefits should go up to cover the cost of renting the property. So I hope that answers that particular question. We have another question that's come in relation to spouse applications. I've not seen this question for a while. Spouse applications, and in particular finances. Let's look at the question that's been raised in relation to immigration law, spouse applications and finances. Question that's been sent in, brother says, Assalamu alaikum. I am intending to apply for a spouse visa for my wife. I am in receipt of PIP, so personal independence payments. Do I have to meet the 18,600 requirement? Do I need a job, or can I rely on my PIP to apply for my spouse's visa? Now, a common scenario, those who will be familiar with spouse applications, where somebody is sponsoring their husband or wife from abroad to come to the United Kingdom, there is a financial requirement that needs to be met. We normally say, you know what, the sponsor, the partner in the UK needs to be earning £18,600 per annum, a proper job, earning that amount of money before they're able to sponsor their partner from abroad to the United Kingdom. Now, that is the norm. That's the general rule. However, there are exceptions to that. And PIP, somebody who is in receipt of PIP, falls within that exception. So you're quite right, brother. If you're in receipt of PIP, personal independence payments, then you don't need to meet the £18,600 requirement. Likewise, somebody who is in receipt of disability living allowance, somebody who is in receipt of attendance allowance, somebody who's in receipt of carers allowance. So normally the disability type of benefits, people who are in receipt of those benefits have more flexibility in terms of sponsoring a family member, a partner to the United Kingdom. They would be exempt from the £18,600 requirement. So they don't need to show 6 months of wage slips, 6 months of bank statements that they're earning £18,600 per year. They can rely on their benefits, whether it's PIP, DLA, attendance allowance, carers allowance. You can rely on those benefits to be exempted from the £18,600 requirement. Now, although, and this is specific to brother who's texted in, although you may be exempted from the £18,600 requirement, you still need a certain level of money coming in, whether it's by means of benefits or whether it's by means of some part-time or full-time employment that you have. You still need to have a certain amount of money coming in. So it's not a case of you're just able to point to a disability benefit that you receive and you're totally exempt from the financial requirement. That's not the case. Although your benefits mean that you don't have to meet the £18,600 requirement, you still need a certain amount of money coming in. What is this amount of money that you need coming in? The Home Office assesses your income with what you would normally receive if you were on income support. So husband and wife would receive in the region of £117 a week. If there's no rental or council tax costs payable, if you're a couple, you would need, as the sponsor, £117 coming in. That can be made up of your benefits, your PIP, your DLA, whatever else you're getting in terms of disability benefits, carers allowance, because you're caring for somebody who's disabled, and any other benefits that you have coming in, such as universal credit, and you could add in your part-time job or your savings as well. But it's certainly much easier to satisfy the requirement in that particular way. So I hope that answers that specific questions relating to PIP and spouse applications. We're taking a short break. Inshallah, we should be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, another popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. I've had a number of questions coming in, so just looking at the WhatsApp messages which have been coming in, which is always fantastic. But you can give us a ring live here in the studios by ringing the landline number as well. Let's look at the next question that's come in, again relating to immigration law and in particular spouse applications. And this is a question relating to a sponsor who is self-employed in the United Kingdom. So the person is self-employed in the United Kingdom, wanting to sponsor I think it's their wife to come to the United Kingdom. And the specific question that's been asked is, what documents do I need to submit if I am self-employed in the United Kingdom? It's quite a long question. I think the brother who's texted in is a taxi driver, self-employed in the United Kingdom, wanting to sponsor the wife to come to the United Kingdom. So In terms of the income requirement, this requirement that we keep on mentioning, that as a sponsor in the United Kingdom, you need to be earning £18,600 per year. That applies to somebody who is employed and who is self-employed as well. The big difference between the two is the type of documents which need to be submitted in order to demonstrate your income. Somebody who's employed has it relatively easy. They would normally, there are exceptions to this, they would normally be submitting 6 months of wage slips, 6 months of bank statements, and an employment letter confirming their employment. Whereas the situation for somebody who is self-employed is different. Obviously, if I'm assuming this is not limited company employment or self-employment, this is you operating as a sole trader. You wouldn't then normally have wage slips or anything of that nature. So there wouldn't be wage slips or an employment letter to submit. However, there are specific documents that you would need to submit as part of your wife's application. Documents which demonstrate that you are earning £18,600 per year. Now, as a sole trader, somebody who's operating a taxi, you would need to demonstrate that your net profits in the last financial year come up to £18,600. Now, the evidence that you need for that would be as follows. You would need your accounts done by your accountant. So your accountant would draft your accounts for the last financial year. And for us, the last financial year, looking at where we are now, would be April 21 to April 22. So you'd look at the income from April 21 to April 22. The accountant would do the accounts for that and would need to show that your income, your profits are at least £18,600 per year, then your net profit. So you'd have your turnover figure. You would then have the expenses taken off your turnover, your gross profits. You would then be left with net profits. So that's the amount that you've earned before you pay income tax and national insurance contributions on that. So that's what you're looking at if you're self-employed. You're looking at your net profits, and that has to be at least £18,600 per year. And the first piece of evidence for that would be the accounts which your accountant will draft for you and submit for you. The second piece of evidence is your tax return. And again, this is something that the accountant will prepare and submit to the Home Office on your behalf. So your accountant will give you your accounts. Accountant will give you your tax return as well. When the tax return is submitted, there is a document called an SA 302, which is generated, which is your tax calculation on your profits, whatever they are, 18,600 or more. The amount of tax that you need to pay, that's calculated. So you'll have a personal allowance, then you'll have a calculation for the amount of tax you've got to pay, the amount of national insurance contributions that you have to pay. So that's the third document that you would need. So you've got your accounts, your tax return, and the tax calculation, which is generated when your tax return is filed. So that shows how much tax has to be paid. The fourth document that you need is a document which shows the amount of tax payable, the amount you've paid, and the amount outstanding. Sometimes this is referred to as the tax overview, or you might get a statement of account at home. If you've got a statement of account at home, you can submit that as well. But otherwise, you should be okay submitting the tax overview. So they're the key documents that your accountant will get together. Your accounts, your tax return, your tax calculation, your tax summary, which looks at the amount of tax you've paid, etc. Now, that's really something that your accountant will be able to assist you with. Separate to that is you having to submit your business bank statements if you have a business bank account, and you have to submit your personal bank statements for the same period as your as the last financial year, April to April. So it would be April 21 to April 22. And your bank statements have been submitted for the Home Office to be able to assess whether you are actually earning the amount that you are saying that you earn. So in this particular example that we've been given, where somebody is self-employed as a taxi driver, what the Home Office would normally want to see is the amount of money received from customers' fares being deposited into, if you don't have a business bank account, it's not a problem, being deposited into your personal bank account. So typically, if you've got about £1,500 to £2,000 being deposited into your bank account on a monthly basis, over 12 months, you would have in the region of £24,000 deposited into your bank account. With that level of deposits, certainly around the £24,000 mark, the Home Office won't raise any queries. They will see that over the year, you've been depositing the money that you've received from your benefits, and then obviously your turnover might be in the region of £24,000. Your expenses, etc., will be taken off, and then you might come up with the end result might be a profit figure of 18,600 or £19,000. So whatever it is. So that's the basic way of demonstrating your income if you are self-employed. So different to how you would demonstrate your income if you are employed, and certainly different to how you would demonstrate your income if you are operating a limited company. So all these different types of income streams that you might have, they all have specific rules relating to them that need to be satisfied in order to demonstrate your income. So employment would be wage slip, self-employed would be these documents, limited company, there are certain other documents relating to the limited company that would need to be submitted as well. So sometimes these matters are a bit complex, and what I would advise is that if your case is anything out of the ordinary, then you do seek legal advice from an immigration law specialist who will be able to guide you. Now, in terms of the other requirements which need to be fulfilled, obviously they remain the same. It's only the income requirement and how that's demonstrated which is different. So in terms of what your spouse would need to get together, and what would have to be submitted, for example, a copy of her passport, her English certificate, her TB certificate, the marriage certificate confirming that you're legally married. Obviously, those documents would have to be submitted. For the income documents, we've discussed the income documents that you need to submit. The other requirements in terms of showing that there is adequate accommodation for your wife in the United Kingdom, that would be demonstrated by maybe submitting deeds for the property, tenancy agreement, a housing inspection report. So these things would have to be submitted. So the other requirements are still there. So we've run through the documents you have from abroad, copy of the passport, English test, TB test, marriage certificate. We've looked at the income documents, accommodation documents. You also have to demonstrate that this is a genuine and subsisting relationship. And on that front, you would normally have to submit photographs together, maybe the wedding photographs, after the wedding photographs, photographs demonstrating that you have met and you have spent time together as well. Now, luckily on the relationship front, it has become much easier because the kind of documents that the Home Office used to request before. Records of call history, message history, money transfer receipts where you're sending money to your spouse, wedding cards, etc. All that has now been done away with. So there's no requirement to submit all that stuff. All that's required now in terms of demonstrating that your relationship is genuine and subsisting is photographs together. So your wedding photographs and your non-wedding photographs together. So what I've done for your benefit is just run through the sort of different elements of the spouse application that you would need to fulfill in terms of the documents from abroad, your income documents, your accommodation documents, and your relationship documents. Now, in my experience, the vast majority of people who are sponsoring their spouses from abroad will take advice from an immigration lawyer. The rules are quite complex, and the problem is if the application is refused, you do stand to lose a lot of money. So I would advise that you do speak to an immigration lawyer in relation to your matter. That, unfortunately, brings us to the end of the show. Inshallah, we'll be back next week. Until then, Assalamu alaikum.